The clerk stopped typing, not slowly, not thoughtfully. Her fingers froze mid-motion, hovering over the keyboard as if the screen had shown her something it wasn't supposed to. She looked down again, then back at the document, then at the timestamp in the corner. She turned the page over. "Just a moment," she said, her voice lower now. My husband smiled. He didn't look at me. He didn't need to. He was already standing slightly forward, close enough to the counter that his shadow fell across the paperwork. His attorney stood beside him, relaxed, confident, one hand resting casually on a leather briefcase that probably cost more than my monthly rent. I stayed where I was, a step back, hands folded, silent. The hallway outside family court was busy in the way only court buildings are. Quiet voices, shuffling shoes, people pretending not to listen while listening to everything. 2 benches were full. A woman with a manila folder hugged to her chest glanced at us, then looked away. Someone coughed. A printer hummed behind the wall. My husband leaned in slightly. "Emergency custody filing," he said, pleasantly. "Filed this morning, expedited." The clerk nodded, but didn't resume typing. She flipped the page back again, then checked the screen once more. Her brow creased, just slightly. His attorney cleared his throat. "We paid the expedited fee. Everything should be in order." I watched the clerk's eyes move, not to me, but to the case number printed at the top of the page. She clicked once, then twice. My husband finally glanced back, just enough to include me in the moment. His expression wasn't angry. It wasn't cruel. It was worse than that, assured, almost amused. "She's not represented," he added, as if that explained everything. "I don't think there'll be any issue." That was the first small humiliation of the morning. Not loud, not dramatic, just quietly stated, in front of strangers, like a settled fact. The clerk straightened the papers and looked up again. "I just need to verify something." She stepped away from the counter. The pause stretched longer than it should have. My husband exhaled through his nose, impatient now. His attorney leaned closer to him and murmured something I couldn't hear. I caught only fragments. Standard, temporary, judge will sign. I stayed still. This was not my first time being talked around instead of talked to. Over the past weeks, I had learned how quickly people accepted a confident voice, especially when it came with legal language and money behind it. He'd made sure of that. When he filed, he did it loudly. An emergency motion, an expedited request, a $4,800 retainer wired the same day. Everything designed to look urgent, everything designed to make me look unprepared. The clerk returned with another sheet in her hand. She didn't place it on the counter right away. She compared it to the first document, aligning the corners carefully. Her eyes moved between the 2 pages, then back to the screen. "I'm seeing something here," she said. "Great," my husband smiled. She hesitated. "This case number already has a custody motion attached." The hallway seemed to quiet, though I knew it hadn't. I could still hear the printer, still hear shoes on tile, but the air around us tightened, like everyone had leaned in without moving. My husband laughed softly. "That can't be right." The clerk didn't react to the laugh. She turned the screen slightly, not enough for us to see, but enough to check again herself. "It was filed earlier," she said, "not as an emergency." His attorney stepped forward now. "Earlier today?" She shook her head. "No, prior." My husband frowned, just briefly, then he smoothed it away. "Well, that must be something outdated," he said. "This is the active filing." I said nothing. I didn't correct him. I didn't look at the screen. I didn't explain. The clerk tapped a few keys, then stopped again. "The system won't let me process this as primary. There's already a pending motion in review." My husband's attorney frowned now. "From whom?" The clerk glanced at me for the first time. Not accusatory, not sympathetic, just factual. "It's tied to both parties," she said. "Filed properly, jurisdiction clean." The smile finally left my husband's face. He turned fully towards me now. "You filed something?" His tone wasn't angry yet. It carried something else, surprise edged with disbelief, like the idea itself was an inconvenience. I met his eyes calmly. I followed procedure. His attorney interjected quickly. "If there was a prior filing, it should have been disclosed." The clerk shook her head. "Disclosure isn't required if the motion was already docketed." Then, she added, "the judge will see it first." That was the second humiliation of the morning. This one, quieter, sharper.
My husband stepped back half an inch, as if the floor had shifted under him. He recovered quickly. He always did. "Fine," he said. "Then let's proceed. This is still an emergency." The clerk gathered the papers together and slid them back across the counter. Not rejected, but not accepted either. "I can't mark this as emergency priority until the judge reviews the existing motion. You'll be notified." "When?" his attorney asked. "Soon. Same judge." My husband let out a short breath, irritated now. "This is about the child's safety." The clerk didn't respond to that. She simply nodded once, professionally, and turned back to her screen. We stepped away from the counter. My husband walked ahead, already pulling his phone out, already composing whatever narrative he needed next. His attorney followed, voice low, reassuring. I stayed behind for a moment. I watched the clerk type again, watched the printer begin to hum, watched my case number appear at the top of a fresh page. No one raised their voice, no one argued, nothing dramatic happened, and yet something had shifted. As I turned to leave, I heard the clerk speak again, almost to herself. "There it is," she said quietly, "filed first."
The clerk called his name first, not loudly, not formally, just naturally, as if the order required no thought at all. He stepped forward immediately, his attorney moving with him, already mid-sentence. I stayed where I was, a few feet back, watching their shoulders angle toward the counter while the space beside them remained unoccupied. No one gestured for me to join, no one clarified my position. The separation happened without instruction, and that made it feel intentional. At the counter, documents slid beneath the glass. Receipts followed. The clerk's posture shifted almost imperceptibly as the paperwork stacked neatly in front of her. Expedited processing was mentioned, priority review. His attorney spoke with the calm certainty of someone accustomed to being believed. I was still not addressed. Temporary. Emergency. For the child's safety. The words appeared again, spaced carefully through the conversation, repeated often enough to sound procedural rather than strategic. Each time they surfaced, they carried the same implication, that the situation had already been evaluated, that concern had already been established, that urgency itself was evidence. When the clerk finally looked up at me, it wasn't to ask a question. "Are you aware of the emergency custody request?" she said, eyes already returning to her screen. "I'm aware," I replied. Nothing followed. No invitation to elaborate, no acknowledgement beyond a brief nod. My response was logged and immediately deprioritized, folded into the process like a checked box rather than a voice. He leaned back slightly then, confidence settling in. His attorney referenced payment casually, almost conversationally, as if it were background noise rather than leverage. $4,800. The number wasn't emphasized, but it didn't need to be. It sat there, clean and exact, signaling preparedness. The clerk's fingers moved faster after that. Not favoritism, efficiency responding to certainty. The emergency filing, they explained, would allow immediate control over decisions, school pickups, medical authorization, temporary limitations until review. The language was precise, measured, deliberately unprovocative. Control reframed as responsibility, restriction reframed as protection. I watched how timelines were referenced without being compared, how dates were spoken aloud but not verified against the system in front of her. I watched the way his attorney aligned the narrative just enough to feel complete without inviting scrutiny. Nearby, the waiting area hummed quietly. Phones scrolled, conversations dropped to whispers. I caught fragments drifting through the space. Stability, reliability, financial consistency, spoken as conclusions rather than considerations. "She's been late before," he said, voice pitched just low enough to sound reasonable. "Childcare, about $1,200. Not unpaid, late. There was also that medical bill, $3,000, still unresolved. Unresolved, not incorrect, not disputed, not settled. A word chosen to linger in records without demanding proof. I didn't turn toward him. I didn't interrupt. I noted the way the clerk paused for half a second longer than necessary before continuing to type. I noted how her eyes flicked to the date column, then back to the summary field. Gaslighting doesn't always sound cruel. Sometimes it sounds administrative. "There hasn't been anything submitted on your side yet," he said, turning just enough to ensure I heard him. His tone wasn't mocking, it was reassuring, the kind meant to end discussion. "The judge hasn't seen anything from you."
For a moment, nothing moved. The clerk's fingers hovered above the keyboard, not frozen, just suspended. Her eyes shifted once more to the case number on her screen, then to a second tab I couldn't see. The pause was brief, easily dismissible, but it was there. She resumed typing without comment. Around us, the system continued its rhythm. Names called, doors opening and closing, decisions progressing whether anyone objected or not. The machinery of process did not require fairness to function, only order. I remained silent, not because I had nothing to say, because reaction would have served the wrong timeline. As we were dismissed from the counter, he gathered his documents with easy satisfaction. The emergency filing had done its work. The assumptions were in place. The tone had been set. "You should have acted sooner," he said, quietly as we passed, close enough that only I could hear. "This won't go your way." I met his eyes briefly. I didn't correct him. I didn't explain, because urgency isn't what decides these things. Sequence does. And as I walked back into the waiting area, I was thinking about the timestamp he never asked to see, the filing he assumed didn't exist, and the reason the clerk had hesitated, just long enough before continuing.
The moment I stepped out of the waiting area, I didn't speak. My mind was already counting every document, every timestamp, every small irregularity I had noticed over the past week. The courthouse hallway smelled faintly of printer ink and polished wood, a scent that usually gave me anxiety, but today it was a familiar territory. I had walked these corridors before, each step measured, each glance purposeful. Every clerk, every posted schedule, every slip of paper could be a clue or a confirmation. My preparation had been meticulous, deliberate, invisible to anyone else. But now, in the hushed hum of fluorescent lights, it felt like armor. I found a small bench tucked near the clerk window, its surface scratched and worn, as though generations of people had rested there with paperwork clutched tightly to their chests. I unfolded my own stack carefully. School attendance logs, medical invoices, payment confirmations, and email threads documenting conversations over the past 3 months. Each file was time-stamped, verified, and cross-checked. I had worked with my attorney weeks before this moment, ensuring that every piece of evidence was not just valid, but strategically sequenced. It wasn't flashy, it wasn't loud, just precise. I had even paid the $2,100 flat filing fee weeks ago, knowing the timing would be critical. Husband's emergency filing was already in motion, of course. I had known he would move quickly, he always did, but his confidence blinded him to the obvious. The law favors those who are prepared, who respect procedure, who understand chronology more than volume. Emergency filings are temporary, reactive, loud. My filing was quiet, time-stamped, and evidence-based. Non-emergency, but more enduring, more unassailable. I glanced at the clock. Every minute mattered. I imagined his lawyer pacing somewhere, already rehearsing arguments, certain that the judge would act on the emergency motion first. It amused me slightly, how overconfidence blinds otherwise smart people. Meanwhile, my own motions were already officially lodged, served to the court, waiting silently in the queue, precise to the second. Judges see timestamps before emotions. That was the mantra I repeated to myself. It was a quiet comfort, but it also made the tension feel sharper. I organized my school records first, attendance sheets signed by the principal, clearly showing routines and pickup schedules. Each form highlighted the consistency of my involvement and stability. Next were the financial proofs, childcare payments, medical copays, a disputed $3,000 invoice that he had tried to leverage as neglect. Each dollar documented, cross-referenced with bank statements. I made sure to leave subtle margins, annotations in the margins that only a keen eye would notice. These weren't flashy, they were precise weapons in a quiet battle. Email threads followed, messages exchanged at odd hours, documenting attempts at communication, requests denied or ignored, and the subtle patterns of control. Every temporary measure, every "for the child's safety" phrase he had used to justify unilateral decisions was highlighted. I didn't react at the time, I observed. Now, these same words would serve as testimony of his procedural arrogance, his assumption that speed equals legitimacy.
I paused briefly to review my own notes. I had created a simple chart, cross-referencing all documents with court dates, timestamps, and anticipated responses. It wasn't overcomplicated. It was a map of facts, a lattice of evidence that would inevitably catch the first flaw in his narrative. And there was one. The emergency motion couldn't override a prior filing, a subtle but critical rule that often caught overconfident lawyers by surprise. My attorney had explained it clearly. Judges respect procedure first, urgency second. Every step I took in preparation had been invisible to him. Every move, every payment, every submission had been done quietly, deliberately, under his radar. While he was building a narrative of urgency, I was building a fortress of evidence. This was the real reversal, the hidden one that no one could see yet, not even him. Then came the micro moment I had been waiting for. A clerk at the window paused mid-typing, eyes scanning her monitor, subtly questioning something. I didn't flinch, I didn't move, I merely noticed. That pause, so brief that anyone else would miss it, was a confirmation. My filing was active, time-stamped, recognized in the system. This tiny reaction was the first tremor of the shift to come, invisible to everyone but me. I allowed myself a faint smile, internal, contained. Patience, I reminded myself, was still the most powerful move. I reviewed my communication logs again. His overconfidence was documented in small slips of language, casual misstatements that revealed gaps and assumptions. Each line was a breadcrumb leading to the inevitable moment when procedure would expose the overreach. I didn't need to gloat. My actions would speak louder than words ever could. The notification arrived unexpectedly, an automated message from the court system. My filing had been scheduled for review, assigned to the same judge who had paused on the first day, the one who noticed timestamps carefully. I read it calmly, deliberately, committing every detail to memory. Courtroom, date, time, reference number, all perfectly aligned with my evidence. I looked at the envelope in my hands. Nothing flashy, nothing dramatic, just official, procedural, unassailable. The quiet power of legality. The irony wasn't lost on me. While he had rushed, assuming action equated to control, my patient, calculated steps had created a position of unassailable authority. The reversal was invisible, unassuming, yet inevitable. As I organized my stack once more, the hallway noises dimmed in the background. Conversations blurred into a soft hum. For a moment, I allowed myself to imagine the courtroom scene to come, not with excitement, not with anger, but with clarity. I would be calm, precise, controlled. Every argument, every objection, every procedural step already anticipated. It was a strange feeling, anticipatory yet contained. My hidden preparation had transformed helplessness into latent power. The system, neutral and procedural, would do what I had already aligned it to do. Emergency filings do not override prior motions. Timestamps, evidence, and proper submission would speak louder than any hurried words, louder than his confident declarations, louder even than the lawyer's practiced posturing. I folded the documents neatly, each stack ordered by category, cross-referenced with logs and court dates. Each line, each paper, each digital record was a silent guardian of the truth. The quiet preparation felt like moving pieces on a chessboard, the opponent completely unaware, the final checkmate invisible until revealed. I left the hallway with a steady pace, every step echoing faintly against the polished tile. No one noticed me, no one suspected the scale of what had already been set in motion, but I did, and in that awareness there was calm, there was control, there was inevitability. Judges see timestamps before emotions, evidence over urgency, procedure over panic. I repeated it silently, a mantra of quiet dominance. My hidden preparation was complete, and the first tremors of reversal had already begun.
The courtroom doors creaked open as we stepped into the chamber, the muted chatter immediately giving way to a heavy, anticipatory silence. The clerk, who had previously been immersed in the endless stream of emergency filings, paused mid-typing, eyes flicking briefly to the timestamp on my motion before returning to his routine as if the simple act of acknowledgement carried the weight of unseen authority. I held my folder tightly, a quiet anchor amidst the undercurrent of tension. Every paper inside meticulously organized, every entry time-stamped, every signature and record aligned to the precise legal requirements. The calm of preparedness was my shield. Across the room, my husband's posture shifted the instant he saw the judge reviewing my motion. His confident stance faltered imperceptibly, a micro crack in the facade of control he had maintained since the emergency filing. His lawyer, previously assertive and commanding in the hallway, leaned in, whispering hurriedly, a muted cadence of uncertainty that he hadn't anticipated. The emergency motion he had rushed to file, paid for with expedited fees and a $4,800 retainer, was suddenly being reframed under the strict scrutiny of procedural precedents. My motion, filed non-emergently but correctly, had already claimed the chronological priority the law recognizes, something neither he nor his attorney seemed fully aware of until this moment. "Your Honor," the attorney began, voice slightly higher than his usual controlled register, "we filed this as an urgent motion for the child's welfare," but the judge's gaze lifted sharply, interrupting him. A subtle yet unmistakable pause, heavy with authority, signaled the shift. The narrative of urgency he had orchestrated was now under the judicial microscope. The judge's calm voice carried across the room, deliberate and unyielding. "It appears there is an earlier filing on record. Can you clarify why this was not disclosed?" The words landed with surgical precision, not accusatory in tone, but inescapably effective. The courtroom seemed to constrict around them, a silent audience to the power dynamic tilting. My husband blinked, once, twice, a subtle but visible sign of internal calculation and rising panic. His lawyer's notes fluttered as he leaned over, whispering, recalibrating arguments on the fly, a live demonstration of procedural vulnerability. I remained seated, poised, expression neutral, my voice silent, yet every observation meticulously noted. The judge scanned my documents, school records, financial statements, communication logs, all filed correctly and in sequence. Each timestamp, each notarized signature reinforced my position not just in law, but in the perception of order and meticulous diligence. I did not need to speak. The authority of my preparation spoke volumes, projecting a quiet but undeniable competence. As the questioning intensified, the subtle cracks in the opposition widened. My husband's interjections became staccato, each sentence slightly more hurried, betraying his initial composure. We weren't aware of this," he said, voice rising slightly, almost reflexively. The judge's eyebrow lifted, a silent reprimand. The courtroom absorbed the tension, the rhythm of legal procedure converting what had once been my vulnerability into a demonstrable reversal of power. Each word, each pause, each procedural acknowledgement reinforced the message. Precedence and legality trumped emotion and haste. The attorney attempted a rapid recovery, referencing procedural norms, emergency clauses, and the child's welfare. Yet even his expertise could not override the chronological truth, the fact that my filing had existed prior to the emergency claim. Emergency filings do not override prior motions without judicial review, the judge intoned, an almost academic tone, but laden with authority. My husband's jaw tightened, his confidence now visibly waning, the veneer of control eroding under the procedural reality I had silently constructed. It was remarkable, almost cinematic in its subtlety, how the courtroom environment itself became a conduit for the reversal. The clerk's earlier pause, the judge's quiet insistence on chronology, the attorney's faltering, all orchestrated into a rhythm that my observation alone had predicted. The power dynamic, previously assumed to be firmly in my husband's favor, shifted incrementally but unmistakably. Every procedural misstep he made was amplified under the lens of meticulous documentation and legal timing. As the hearing progressed, the judge carefully dissected the sequence of filings. Each reference to a timestamp, each verification of service was noted with deliberate neutrality. There was no dramatization, no sensational rhetoric, only the unassailable weight of methodical preparation. I felt the tension crystallize into clarity. My husband's emergency filing, hastily prepared and reliant on perceived advantage, was systematically deconstructed by the silent, objective authority of law. The courtroom, for the first time, seemed to recognize me not as the excluded party, but as the one whose actions had been deliberate, legally sound, and fundamentally uncontested. At one point, the judge addressed my husband directly, voice firm but calm. "Can you explain why the earlier motion was not included in your filing? Were you aware of its existence prior to submission?" The silence that followed was heavy. My husband's lawyer muttered something, almost inaudibly, and the client himself looked at me, a fleeting expression of shock crossing his features. Not anger, not embarrassment, but the sudden acknowledgement that the procedural reality had surpassed his assumed control. I remained composed, outwardly unaffected, though internally each micro moment reaffirmed the painstaking strategy that had led to this confrontation. Small procedural victories accumulated visibly. Each verification of receipt, each acknowledgement of chronological precedence reinforced the narrative that had remained hidden until now. The judge referenced specific lines from my submission, communications, school attendance logs, documented financial contributions, all silently contrasting with the hastily prepared emergency claims. The audience, other observers in the courtroom, felt the subtle shift. It was not theatrical, it was methodical, precise, undeniable. Power, once wielded arrogantly by my husband, was now realigned by process, law, and documented diligence. By the time the review concluded, the courtroom atmosphere had transformed. The almost confident claims of urgency and authority were rendered tentative. My husband slouched slightly in his chair, muttering quietly, his lawyer revising arguments, attempting to salvage credibility. I, however, remained poised, my attention fully on the judge's reactions, noting each subtle nod, each adjustment in tone. The authority had validated truth. My filing stood first, my procedural integrity unchallenged, and the emergency claim, though loud and imposing initially, was now constrained within the boundaries of judicial scrutiny. Finally, the judge concluded the session with clarity and measured firmness. Emergency filings are intended for unforeseen circumstances. When prior, properly filed motions exist, those take precedence. The court acknowledges the chronological filing and will proceed accordingly. No dramatics, no gloating, just undeniable procedural victory. My husband's reaction, a mixture of frustration and reluctant acknowledgement, was almost imperceptible but telling. His authority had been quietly, irrevocably challenged. I exhaled softly, not a sigh of triumph, but a subtle release of tension. Preparation, patience, and adherence to the law had quietly dismantled the narrative of control he had assumed. In that courtroom, among the silent observers and official documents, the reversal was complete. Authority had spoken, and it spoke in calm, measured, irrefutable terms. I did not need to raise my voice. My filing, my diligence, my silent endurance, these had been enough. The balance, for now, was restored. The moment the courtroom doors closed behind the last late entrant, a weight settled over the room, dense and deliberate. My folder, once an object of quiet preparation, now rested heavily on the polished wooden table before me, yet I did not fidget or adjust it. Every document, every time-stamped record, every carefully organized communication log was accounted for, ready to speak for itself. Across from me, my husband's posture stiffened further, the confident tilt of his shoulders faltering imperceptibly under the watchful gaze of the judge. His lawyer shuffled papers nervously, glancing at the judge's hands resting lightly on the bench, the robe-capped authority radiating calm scrutiny. The judge cleared her throat, not harshly, not accusatorily, but with measured attention. "Miss Carter," she said, her voice smooth but firm, "the court has reviewed both the emergency custody motion filed by Mr. Reynolds and the prior motion filed earlier by you." She paused, letting the names and papers settle in the courtroom's tensioned air. "The timestamps, filings, and supporting documentation are clear. The precedence of your prior motion is legally recognized. The emergency motion does not override established procedures." A subtle murmur ran through the small gallery of observers, mostly courtroom staff and a few family members. My husband's jaw tightened imperceptibly. His lawyer, usually articulate, swallowed and glanced down, fingertips tapping nervously on a thin stack of papers. I remained still, eyes forward, voice unnecessary, presence enough. The law, methodical and impartial, had become my quiet ally. The clerk, seated nearby, adjusted a stack of files without meeting my gaze, yet I felt the silent acknowledgement. The system had been prepared, checked, and balanced in my favor. My husband's earlier smirk, the one he wore with certainty in Part 1 and throughout Part 2, had vanished completely. He attempted to interject, a half-formed protest about child safety and urgency, but the judge raised her hand slightly. The court will not entertain arguments that contradict established legal precedents, she said. Calm, factual, devoid of indulgence. The words were final yet restrained, echoing the procedural rigor that had guided every step of my preparation. I leaned back slightly, feeling the invisible tension dissipate in measured increments. The emergency motion had been denied. The original filing, my filing, was proceeding. Temporary custody arrangements reverted, and all orders were realigned with the first submitted motion. There was no gloating, no spectacle, no dramatic flourish, just a courtroom returning to its logical and procedural order. In those moments, I reflected quietly on the chain of preparation that had led here. Weeks of organizing school records, medical statements, and financial documentation. Every carefully dated email, every time-stamped message had mattered. The law rewarded preparation, patience, and calm, not noise, not bravado. My husband's financial advantage, his aggressive filing, his confident assumptions, all had been neutralized, not by argument, not by confrontation, but a quiet mastery of process. The judge continued, addressing the broader implications, her tone measured. Emergency filings are tools intended for unforeseen circumstances that require immediate attention. Misuse, as demonstrated, undermines both the process and credibility. Parties are reminded that procedural integrity is paramount. The court expects adherence to timelines and transparency in all motions. The words were precise, leaving no ambiguity. Authority, in its quiet power, had reinforced not only the immediate outcome, but the principle itself. I exhaled silently, my mind tracking the small changes in the room. My husband no longer carried the commanding posture. His lawyer's subtle fidgets betrayed mounting uncertainty. Observers glanced between the documents and the judge's calm demeanor. And yet, despite the shift in power, there was no need for triumphal gestures, no need for emotional statements. The narrative had been completed not by rhetoric, but by law, preparation, and timing. Sitting there, I allowed myself a brief internal reflection. Silence had never equated to weakness. In the weeks leading to this day, my patience had been mistaken for passivity. My composure had been misread as indecision. But the system, unbiased and methodical, had validated strategy over spectacle. The quiet observance, the meticulous documentation, the calculated and lawful steps, these had ensured a victory that was inevitable once the facts were presented. Finally, as the clerk collected the files and the courtroom's formal cadence returned to routine procedural rhythm, I rose, collected my folder, and walked toward the exit. My steps were calm, measured, deliberate. No one needed to see relief. No one needed to hear a statement. The authority had spoken, the legal outcome was secured, and the balance, though temporary though it might be, was restored. Just before leaving, my eyes met the judge's briefly, a nod of recognition passing silently. It was acknowledgement of the principle as much as the person. Preparation, legality, and composure overpowered arrogance, haste, and assumption. I did not need to file loudly. I did not need to confront noisily. I only needed to file first, accurately, and thoroughly. Outside the courtroom, the air was sharper, brighter, carrying with it the quiet satisfaction that comes not from spectacle, but from procedure, precision, and patience. I walked in a participant in a tense legal game. I walked out a quiet witness to its fair outcome. Justice, subtle and procedural, had affirmed itself, and in doing so, it affirmed me, not by rhetoric, not by emotion, but by the calm, inevitable force of meticulous preparation. And in that quiet, inevitable way, I realized the story of the emergency motion, the confidence, the attempts at dominance, had all ended not in conflict, not in drama, but in the measured, undeniable truth. I didn't need to raise my voice. I didn't need to assert loudly. The law, the system, the facts, they had done it for me. The courtroom doors closed behind me, final and deliberate, leaving only a single thought lingering. Silence, preparation, and patience had always been enough.